Got a lot of stuff, but toward the end of the show, I found out that Joe Jackson had passed, the father of Michael Jackson, Latoya, and Janice, and Janet, and others. What do you have, 8 children?
Nine in all,
9 babies.
and possibly two unconfirmed half kids.
Still worker. Guy who aspired to be a boxer, described as a pretty hard father, as a patriarch. He was a father. Well, came from a rather fairly large family of 5 himself. I always liked Joe Jackson. I grew up with the Jackson 5, by the way. But I always liked their daddy. He was kind of, you didn't see him much, but when you did hear from him, you knew he didn't take any stuff, especially from his children, as he should. He's a lot like my daddy. In many ways. My daddy was a Golden Gloves boxer, cement finisher, very quiet, but very firm. Something to be said for that, by the way. I thank him for what I am today. But it wasn't until I hired a guy by the name of E. Rodney Jones. It's going back to, somewhere around, I guess, to 1990, 1999, 2000. You know, ladies and gentlemen, E. Rodney Jones was one of the greatest personalities in what was then called black radio. He literally controlled black radio in many aspects as a program director. He made artists. And he was the one, actually, who discovered the so-called Jackson 5. He had a voice that was incredible. Very gravelly. But when you heard E. Rodney Jones doing any kind of commercial or anywhere, anyhow, you took a listen, especially when he was the MC, when he introduced you on stage, be it at the Apollo or be it at the Fox in Atlanta, be it in Chicago, or Detroit. And I chatted with him after hiring him, and he was just an incredible soul. It was like talking to living history with how he interacted with the likes of Aretha Franklin. And then he told me about how the Jackson 5 came to be, and it was as a result of Joe Jackson contacting E. Rodney Jones and saying, E. Rodney, you got to get my boys on. So we looked back into our archives, and I actually found some scripts of what E. Rodney sounded like. He was on the network here that we have that basically is the only African American blues network 24 hours in the nation. And it was uplinked by satellite Galaxy 5, and it all emanated from this office. Incredible. Incredible. Want to know what he sound like? Here it is. Here is E. Rodney Jones.
Weekday mornings, it's a new day with Rip Daniels on your platinum station, JZ 94.5. If it's blues you want, if it's blues you need, if it's blues that you would like to hear, anywhere else in the country, you won't find the blues like you will find the blues on the American Blues Network.
I smile because E. Rodney was driving from Baton Rouge to Gulfport. You know what I paid him, bro? Zip. When he first started, I paid him absolutely positively nothing. I couldn't pay him anything, but it was a time when you did things in this business for each other, and he wanted it to work. That was in the beginning. I paid him nothing. However, I continued to pay him long after he stopped working here until he passed there in Baton Rouge. But it was he who pulled my coattail to the backbone of the Jackson family, and it was Joe Jackson. There's no doubt about that. He didn't settle for less. Practice, practice, practice. When he found out that his children were talented, he moved them from Gary, Indiana. He quit his job and committed to his children and their success. And of course, it resulted in his success. Success is not measured, however, by how much money you make, ladies and gentlemen. It's measured by where you expect to be in life. My daddy told me that. can't put a number on what is successful. For some, $1 million is success. For others, just simply graduating your children from high school is success. You decide what it is. So I saw that and I thought about it and I said to myself, don't make fathers like that anymore. Got married when he was 18 years old. Eked out a life for his family, and what a life it was. So let's get to it here, folks. I need to give you some background. For those of you who are young and think that somehow or another this great country of ours just simply existed. You know, and I really think that, bro. I think that your generation and generations behind yours just kind of feel that this whole thing called America just kind of evolved and it's just here and it just happens. It did not. When you read history, you realize that how this country came to be this country was tumultuous. And I'm not just talking about the Revolutionary War. I'm not just talking about the Civil War. I'm talking about long after then. Long after then. Americans were not getting along with Americans. And I'm not talking Native Americans, so-called Indians, and the colonists, or the Europeans. Or for that matter, I'm not talking about those who enslaved and the slavers. I'm talking about all of us as Americans. And the only way we were able to survive this without tearing this country apart was because of the Constitution. The Constitution. See? That's why when officers and when soldiers go volunteer and join, or when they don't volunteer, when they're drafted, you swear an oath to defend the Constitution. Because it's the Constitution is that thread that holds this country together. We may not like each other as an American. We really may not. But we're in this together because we live here. You got me? Sort of like being brothers and sisters, and some sisters and brothers you don't like. Even stepsisters and brothers you don't like. But if you're in the same house, guess what? If it catches on fire, you all could burn up. So that's what this is all about. So with that said, ladies and gentlemen, there's been a tug of war going on since the creation of the Constitution. That's what the Federalist Papers were all about. You know, Hamilton, Madison, the North, the South, Calhoun, Adams, that whole tug of war as to how to interpret the Constitution. What does it mean when it says we the people? Who does that include? When the Constitution was first written, we the people were actually Caucasian males. They were the only ones that could vote as per the Constitution. But thank God that the fathers and stepfathers, grandfathers, or baby daddies in some cases, who wrote that Constitution, put in the ability to amend it because they knew that document was a growing document. That it was possibly not all that, it was not inclusive as to what would happen, 3 centuries from now, or from then. Now there are those who think, I have a strict interpretation of the Constitution. Well, how the hell could you have that when there's a means of amending it? Just think about it. In other words, the wisdom of the founding fathers and stepfathers was that, hey, look, we can't. I mean, we don't know what's going to happen in America after 1776. What's going to happen in 2076? We plan on being here, and so just in case those coming after us need to amend it, then we will. So now, with that said, I want to go into what's about to happen here and how we arrived here, because we're in a very bad place again. And it didn't just start with Donald John. It actually started with Ronald Reagan. It actually started going back to, not even with him, it actually started with Abe Lincoln, really. Or after Abe Lincoln was assassinated. The interpretation of the Constitution was perceived as being strict or liberal, loose, right? In other words, some of you believe that thou shalt not kill means thou shalt not kill, period. Over in the story. Of course, another pastor might interpret that differently. That thou shalt not kill unless you kill someone else. So it's all about the interpretation. and I don't want to get too far afield here. So that strict interpretation and that liberal interpretation was the bedrock between what is conservative and what is so-called liberal. Right? When you hear somebody say, I'm a conservative, I'm a liberal, these days it means actually Klan-servative, those who have basically the characteristics of Klansmen, Ku Klux Klansmen in many cases. That's what it means. I don't mind I don't mind reiterating that later, but I want to continue here because I'm talking about something very critical. So those individuals who thought that way the Constitution applied to all people, in other words, and not just Caucasian males, that had to go before the Supreme Court, ladies and gentlemen. No, it didn't just take a war. The Supreme Court had to in fact, rule that Negroes who were born in this state, in these states, were in fact citizens. They were. Of course, it resulted in, of course, an amendment, the 14th Amendment to the Constitution. Right? But still, the courts had to come out and say, well, okay, yeah. There were those who challenged that. They challenged that whole concept. When I say those, I'm talking states challenge it. Or any American can challenge it. So what you had were laws then, thereafter, after the Civil War, that were coming out, that laws that started to be more and more like, well, there were segregation laws. It became a fascist government whereby there was white rule, in quotes. It was. Majority rule meant in many states like Mississippi that white ruled. And that in this case, white Caucasians could in fact have special privileges. That's what segregation was all about. I was there, I know. Which resulted in many cases going before the courts because there were laws, actual laws on the books in the states. And the states felt that they had a right to do it because it was states' rights. All the laws, by the way, it's in the Constitution, all the laws that were here, not hereby originated in the Constitution, were then derived by the state. The states can come up with their own laws. We can segregate movie theaters, we can segregate this, that, and the other. And especially because they thought that, because there was another case that came before the Supreme Court. I think it was around 1818, it was after the Civil War, 1880, 1881, during the Reconstruction row. Find out. The Supreme Court ruled, I think it was 1887, the Supreme Court ruled that it was okay. In other words, that businesses can segregate. Because there was a law put forward that, okay, there was going to be a desegregation and then of all businesses and so forth, and the easy and the open access of all people, regardless of race, color, religion, and so forth. The Supreme Court struck that down. They struck that law down. This is in the 1800s.
1873.
Yeah, there you go. 1873. Thank you. I said 1873. Yeah, you see it?
I see it.
You have the law there?
Civil Rights Act outlawed segregation in private. No, this is not it.
Yeah, it did.
Is it?
Yeah.
Civil Rights Act outlawed segregation in privately owned businesses.
That's right.
In 1873, U.S. Supreme Court declared it unconstitutional because the 14th Amendment only limits state power.
There you go. That's exactly right. So it said that the states could, in fact, have segregation, and so here we are. Turn the clock forward now, and you get into the 1950s and the 1980s, and you had what's called the Warren Court. It was the Warren Court, ladies and gentlemen, that really established modern-day so-called conservatism. Because there are those, and you'll hear them, when you hear someone say they're conservative, what they're saying is that they don't want legislation from the bench like the Warren Court. The Warren Court. We're talking about Justice Warren, ladies and gentlemen, Chief Justice Warren as he became. Of course, inside that court became Thurgood Marshall as well. But what Warren did in the Warren Court, and his, I don't mind telling you, his co-justices, they were the ones who put forward the Brown versus the Board of Education, Topeka, Kansas case. Which in that case, landmark case, it declared the state laws establishing separate public schools for black and white students unconstitutional. That was the Warren Court. It challenged every law in the South. Well, not only in the South, by the way. Ohio, which is in the North, had its segregation too. It did. And so conservatism, modern day conservatism said, whoa, wait a minute. The courts just ruled that against the state law, declared those state laws unconstitutional. And they're legislating from the bench. Just so happens that Warren was on that court, Chief Justice Warren. And it was a close decision. Where was it? 5-4? Oh, no, I'm sorry. It was unanimous. 9-0. All the justices says, no, you can't segregate.
No.
You can't segregate primarily because, in their view, it did not offer equal opportunity. You know, life, liberty, and the pursuit of happiness. Every American should have equal opportunity. Now, that doesn't mean, ladies and gentlemen, that they can go in and force individuals, but when it comes down to something ex officio like a public school, then you have to have equal opportunity, equal access. Can't be segregated. So much of the legislation during the Warren Court was about, in fact, equalization. It was wiping away the white supremacist view of what America is supposed to be. The fascist concept of white only. Look, I'm just telling you how it did.
The concept that permeated throughout the beginning and up until this point.
Modern day conservatism was built on this, on the premise that the courts overturned and took away the rights of white people, end quotes. How dare they? We have a right not to be around those people. They stink. Besides that stuff might rot off. That melanin might rub off.
Brown might come up. We don't know.
Especially when it comes down to being on a train or a bus or in a restaurant or whatever. In a school. We can't have that. Misogyny. Amalgamation of people.
Might just start turning brown or something.
1968, Green versus the County School Board of New Kent County. The Supreme Court was dealing with the freedom of choice plans created by that as a result of the Browns decision. And this state, Mississippi and others, tried to get around that by coming up, well, it's separate, but it's equal, and all of that, and blah, 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 blah. On and on. The Warren Court ruled on many situations like this that really pissed off conservatives who, by the way, were in the Democratic Party. See, it's not Democrat or Republican here, folks. It's conservative or it is moderate/liberal. The conservatives were adamantly against integration. Adamantly against integration. It had nothing to do with being the Democrats. It had more to do with being conservative. Then, of course, there was Baker versus Carr. Voting restrictions. This is involving apportionment, whereby you go in and you divide. This is a case about gerrymandering, where you go in and say who can and who cannot vote. You divide the districts. Well, it was a landmark decision there in this case that retreated from the court's political question doctrine, deciding reapportionment. In other words, what this said was the states were saying, look, the courts and the federal government can't decide about how we reapportion, how we draw the lines in our state. It's up to the states to do that, and the legislature. In that case, Baker versus Carr, the court said, no. We decide. It is within the realm of the federal government to decide how you divide the American taxpayers and the voters. It was this decision, ladies and gentlemen, that said that the federal courts has oversight because there were states that were running amok. You got to understand, the southern states had disenfranchised African Americans. There were fewer than 100 African Americans registered to vote, ladies and gentlemen, in 1940. It may have been 172, if you count Mount Bayou. You understand that African Americans were prohibited from voting, either by force or by law. And so the Warren Court was saying, no, that's not all. How about this? Escobedo versus Illinois. In the criminal procedures, it was a landmark decision in the Warren Court holding that criminal suspects have a right to counsel during police interrogations under the Sixth Amendment. African American came and he was being questioned without counsel, and the Warren Court said, no, you can't question that man. He has a right to counsel. Oh, the Warren Court, let me just tell you time and time again it came in. Of course, many of the conservatives looked at it as if it was the black man's court. You got that black man. He just out trying to protect the black man. When, ladies and gentlemen, the laws protected all men. But because African Americans were in fact, the cases brought were in fact defended all the way to the Supreme Court, and they won. You gotta understand something now. In this case and other cases, those who fought the Supreme Court and paid for that court case going there was the states. The states with tax dollars from Negroes were being used to keep Negroes in check. Talk about taxation without representation. What about criminal procedure? For those of you who don't know the Warren Court and how it participated. This is the court that conservatives hate. When you hear them say they're legislating from the bench, they're talking about the Warren Court. You hear someone say they're conservatives, ask them about the Warren Court, and then you'll understand. I just didn't like those justices there. So what did you didn't like? Which one of these court cases you didn't like? United States Supreme Court case discussing the nature of the, get this, right to privacy and the legal definition of search. The court's ruling adjusted previous interpretations of the unreasonable search and seizure clause of the Fourth Amendment. What did it say? Well, it just simply said, well, no. You should be safe in your effects. Which, by the way, here recently came up again. Right? To show you how important this court case stuff is. Hang on, just bear with me. Because you see, the Warren Court laid the basis for protecting the individual from the states. You got me? By defining this, it said that Rip Daniels is more a citizen of the United States than Mississippi. Mississippi cannot deny Rip Daniels rights that ordinarily he would have in the United States.
Your citizenship to the nation supersedes your state citizenship?
Right, because what the states were trying to do was say, well, no, he's in Mississippi, and so therefore we can impose another law. Now, there are some laws that apply only to the state. There's no doubt about that. But my civil liberties were henceforth and forevermore protected by the federal government here, over and above what the states can divvy out. And they try to take those rights every time. That's what Roe v. Wade is all about. That's what this whole, when you hear like this state just came up with a law that says, okay, you got to have, we'll give you 15 months as far as abortions are concerned. You don't understand, Roe v. Wade, that is a case about privacy. It is not a case, ladies and gentlemen, about abortion as much as it is a case about privacy. States sought to limit the privacy of women in their birth. That is a thing between them and their doctor. Now, if it's not, then that means that the federal government should be able to go in and cut that baby out of you and keep that baby. Now, I know as horrible as that sounds. And look, folks, don't go trying to evaluate Rip Daniels. Oh, that's horrible. No, it is privacy. A pregnant woman has as much privacy as a person who's not pregnant. So at what point do you say to that woman, the federal government can order you to do with your body what it wants? I'm not going that route yet. I'm just simply laying this out because, ladies and gentlemen, the court activity right now is very vital. Just recently, what was this, Monday? Tuesday? Friday. On Friday, the Roberts Court now, Warren is dead. Chief Justice Warren is dead. So is Thurgood Marshall. But boy, those conservatives are still bitter about it. So now you got another court, right? Roberts appointed by George W. Bush. By the way, Roberts has proven that he is giving some consideration more to the application of the Constitution based upon not politics, but based upon what's good for the country. Just Friday, listen to me closely because there was a case decided and most people are not dealing with it, but it goes back to that searches and seizure case that was decided in the Warren case. If you are a criminal, you need to listen closely. Or if you're a potential criminal, listen closely. On Friday, the courts decided that in a case of Timothy Carpenter, who was a bank robber, Carpenter was the ringleader in robbing banks in Michigan and Ohio. Well, the police went in and said, we got to catch this guy. So they ordered the cell phone companies to provide for them information on his cell phone, where he was.
Geographical GPS?
Oh, absolutely. And so the cell phone companies acquiesced to the law enforcement, and guess what? Every time that bank was robbed, there was Timothy Carter. Timothy Carter's phone was there.
Did a lot of business with this bank.
They were able to, well, it wasn't just this bank, it was a string of banks.
Oh.
Everywhere a bank was robbed, Timothy Carter was there. They were able to see his cell phone was there. The information was placed there at the robbery sites. Well, listen to me closely. Because the Supreme Court ruled, they ruled against law enforcement in this one. Yes, they did. Thanks to Roberts. The courts declared that the routine court order that the police obtained in Carpenter's case required only a showing that the police were seeking relevant information. He was not charged. He was just an everyday citizen, and the whole idea of allowing police access to that information was unconstitutional. It constituted unreasonable search and seizure, Ro.
Well, all right.
A search warrant requires the police meet a far higher standard than that.
And they should.
That's right. Look, listen to this. Judge Roberts wrote in this. Let's see, where is it? The case before the rights of the Constitution. Oh, here it is. Judge Roberts. He said cell phone locations at a radio gate. And it has almost near perfect tool. He said law enforcement has an almost near perfect tool for government surveillance, and it does. For those of you who just think that you got your cell phone and it can't be tracked, you're just crazy. And wherever your cell phone goes, that orange dot goes. Wherever you are, beep, beep, beep. At any given time, anybody, police, can say to the cell phone company, where is this phone? Ultimately, I don't doubt that, people will be able to do it, period. I really do, folks. I think there's going to be an app. Now, there is an app. You can go volunteer as a business and have an app to find out where, if you have a company cell phone, you can find out where it is. Now, but what this says is that law enforcement can go to your cell phone provider and say, on this tower, I want to see who all was on this tower, and then they just simply go down the line and pull up the number and go there. Yep, he's there. Well, Chief Justice Roberts says that's near perfect. It's a near perfect tool for surveillance. And he says this, the writers of the Constitution, he said, would certainly have understood that an individual has a privacy interest in the day-to-day, hour-to-hour, and even minute-to-minute records of his whereabouts. A privacy interest that requires the government to get a search warrant before gaining access to that information, and the Supreme Court ruled on that, which means now, law enforcement can't just arbitrarily say, we think it was Rip Daniels. Let's just check the cell phone tower and see if he was there.
Can't do that.
Without a warrant. You got to have a warrant. Which means the judge has got to say, well, let's see, now, why do you want this warrant? Why do you think Rip Daniels had anything to do with it? In other words, there has to be a standard. There has to be some indication that there's a great possibility that Rip Daniels participated in the crime. Not just that Rip Daniels was there. I don't know, law enforcement, you guys don't like this, and I know it's going to make your job difficult. I know that. But the courts had to rule on this, which brings me to my main point. Justice Kennedy now is retiring. He was one of those who decided in that case. It has been the courts that has moved the pendulum of individual freedom in this country, even more so, in my view, than the founding fathers or the Congress. Because when those laws come out that are unconstitutional, and there have been many, little old average citizens like Rip Daniels will take that to the Supreme Court. And the Supreme Court then has to consider, based on the Constitution and that interpretation, what is best not only for Rip Daniels, but for every citizen. Now, if you add politics to that, which is now starting to happen, actually it started to happen after Abe Lincoln, then we end up in a very horrible place, in my view. A conservative judge, a liberal judge, really? It's one thing to have a strict interpretation, another to have a liberal interpretation. That has nothing about being a conservative or a liberal. Unfortunately, ladies and gentlemen, we've reached this point. And we've got a president here who's looking for someone who's already decided. Already has his mind made up on certain issues, be it gun control, be it abortion, be it whatever. You're not supposed to have a litmus test, and really, justices are supposed to be apolitical. Not Republican, not Democrat, not conservative, not liberal. But now it's all out in the open. And the whole idea of getting an impartial judge, unfortunately, seems to be out of reach, and that is sad. There are incredible justices, and to fair judges, fair justices. Those who interpret law not based on politics or based on paying tribute for those who appointed them, but instead based on the intent of the laws of the Constitution. So get ready for this. Get ready for this fight, and get ready for a different kind of America. And don't just think that America can't change, because when the laws change in my great country, this country will certainly change. So we'll be back.
The Breakfast Club. Each and every weekday morning, if you missed the show, this is what you missed. Today is National Forgiveness Day. We're having people call up to forgive people. All of them.